You've got mediation coming up in your custody case, and everyone is telling you, just be reasonable. But what no one is telling you is how mediation actually works, who's in the room, and what could go seriously wrong if you are not prepared. Here's the truth. Mediation isn't just a conversation. It's the first battleground in your custody case. And for many fathers, it's where the tone of the entire case gets set. I'm Mark Reel Jr., the father's rights attorney, and today I'm going to break down exactly how to succeed in California child custody mediation. Today we'll cover what Family Court Services, or FCS, actually does, the law that makes mediation mandatory under Family Code Section 3170, the difference between recommending and non-recommending mediation, and which counties do which, and how to present your case so you protect your rights and your time with your kids. If you've got an upcoming FCS mediation in Southern California, this video is your game plan. If you do, go ahead and click the link in the description and schedule your consultation with Real Father's Rights, because what happens in the mediation room can change everything for you. Why is mediation required? Let's start with the law. Under California Family Code Section 3170, if you and your co-parent don't agree on custody and visitation, the court must refer you to mediation before it can issue custody orders. Here's what the code says. If it appears on the face of the petition, application, or other pleading that custody or visitation is contested, the court shall set the contested issues for mediation. This means that before a judge will rule on your parenting time, both parents are sent to a court-connected mediation, usually through a program called Family Court Services, or FCS for short. So no, you can't skip it, and yes, how you handle it matters. Next, what is Family Court Services? FCS is a department within the Superior Court that provides mandatory child custody mediation in contested cases. They assign licensed mental health professionals, a mediator, who will meet with both parents and try to reach an agreement on legal custody, physical custody, parenting time, exchanges and schedules, holiday time, and communication methods. The mediator may meet with you together or separately, depending on the county and whether there are allegations of domestic violence. In some counties, this happens in person. In others, especially post-pandemic, it's via Zoom. But either way, what you say in that room can influence the outcome of your case. Next, recommending versus non-recommending mediation. Here's where things get serious. Not all mediation works the same way. In San Diego, Riverside, and San Bernardino counties, FCS mediation is recommending. That means that if you and the other parent don't agree, the mediator will write a formal recommendation and send it to the judge. That report becomes evidence in your case, and in many instances, the judge will follow it very closely. On the other hand, Los Angeles and Orange counties use non-recommending mediation. That means no written recommendation is made unless the parents reach an agreement. If you don't reach a deal in non-recommending counties, the case goes back to the judge, who decides custody without any report from the mediator. So strategy depends on where your case is filed. In recommending counties, treat the mediator like a judge. Anything you say may end up in the report. In non-recommending counties, build trust, stay calm, but don't cave. The mediator won't file anything unless there's an agreement. Next, how to prepare for mediation. Let's talk tactics, because preparation makes the difference between walking out empowered or walking out ambushed. First, know what you want and why. Walk in with a clear plan for custody and visitation. Be able to explain it using your child's schedule, school, and well-being. Second, be child-centered. Say things like, I want our daughter to have consistency during the school week, not, I deserve 50-50 because it's fair to me. 3, control the narrative. If the other parent is making false claims, bring documents, emails, texts, calendars, anything that shows involvement and stability. In some counties, you'll want to file that stuff before your appointment. Number 4, don't take the bait. If your ex gets emotional, accusatory, or dishonest, stay calm. The mediator is watching. You want to look like the problem solver, not the source of the conflict. And number 5, practice beforehand. If you're working with Real Father's Rights, we'll prep you with mock questions and mediation strategy. You should never go in cold. What happens if mediation fails? So let's say mediation doesn't work. What happens next? In non-recommending counties like Los Angeles or Orange, the mediator simply reports that no agreement was reached. That's it. There's no report, no recommendation, and the judge decides custody at the hearing. In recommending counties like San Diego, Riverside, and San Bernardino, the mediator files a report which the judge will review before the hearing. If the report is biased or based on false information, your attorney can object to it, request a hearing to cross-examine the mediator, request a full 3111 evaluation, prepare for a contested custody hearing with witnesses and exhibits. The key is to not get blindsided, know the kind of county you're in, and plan accordingly. Final thoughts from the father's rights attorney. Here's the bottom line. Mediation is more than a formality. In California family courts, it's the first and sometimes the most important step in your custody battle. And under Family Code Section 3170, if custody is contested, you must go to mediation before the court makes orders. If you're in Southern California, you need to know whether mediation is recommending or non-recommending. This is on a county by county basis. Next, how to prepare your strategy and what to do if the session doesn't go your way. At Real Fathers Rights, we help dads prepare, rehearse, and walk into mediation with confidence. And if you'd like to talk to our team, click the link in the description to schedule a consultation. Because when it comes to your kids, your voice matters, and we'll help you make sure the court hears it. Thanks for watching. Like and subscribe, and drop a comment if you've got a mediation story or question, and we'll see you in the next video.